My name is Michael Cooper, and I chair the Council on International Affairs here at the City Bar Association. First off, I'd like to apologize right up front. I have a terrible chest cold, so my voice is about an octave or two lower than it usually is. I'll do my best to sort of project, and I hope that you can hear me. Before we start this evening's affair, there are a couple of preliminaries that I need to get out of the way. So the first, of course, is that, reminding myself as well, it's a really good time to disarm yourself, turn off your cell phones. I'd also like to let you know that there'll be a small reception afterwards if you'd like to join us and have more questions for our guest speaker this evening, or to mingle among yourselves as well. Finally, we'll have a Q&A session at the end of tonight's presentation. And, excuse me, I know that when you rise to speak, I hope that you will know that your words this evening are the most important words that will be spoken here. And therefore, I would encourage you to wait for the microphone. We are recording this session tonight, and we wouldn't want any of our offspring in the years to come and decades to come will want to watch this film to miss your very important words. So if you have a question, raise your hand. I'll recognize you, rise, and then have a dramatic pause and wait for the microphone to be brought to you. I'd also like to thank a few folks in the crowd. First of all, thanks to all the members of the Council on International Affairs that is sponsoring this event tonight. I'd also like to thank our friends co-sponsoring from the International Human Rights Committee, Lauren Melkus, who's here with us this evening. Simon O'Connor chairs our United Nations Committee, also a co-sponsor. Thanks as well to the ABA section on international law and to Bruce Rashko for bringing their support to us. Also, Anna Wolenche, I'd like to thank her, the Secretary of the Council, and Larry Johnson as well for making this evening possible. Where are you, Larry? Thank you, Larry, so much. And the staff at City Bar, of course, as well. Finally, I'd like to thank the Jacob Blaustein Institute for the Advancement of Human Rights, Felice Gare and Kristen Broker, who's here with us this evening. Felice and I worked together 20 years ago on the 50th anniversary of the Universal Declaration of Human Rights, so I was really grateful for their support, especially of the reception this evening. I'd like to say just a couple of words about the Declaration before I introduce our guest speaker. I first encountered the Declaration in graduate school. It was assigned to me by a professor one evening, and I must have read the document 4 or 5 times that night. I was really stunned, and quite frankly, I think my first reaction was anger. I was angry that no one had ever told me about this before. I grew up in a sort of, I can say a relatively poor family in northeastern Ohio, working class family, and I had never heard about this document. I knew that I had certain rights. I guess we all do as human beings. We have an innate sense of our human rights. We know that, if your older brother punches you in the head, you have a sense of wrongdoing. You don't need to read the Universal Declaration of Human Rights to know that, right? But there were certain rights that surprised me, the right to health care, the right to food and clothing and other things. So I was really a bit upset about it, and I realized that it was really a twist of fate that I had discovered the Declaration at all. And so for me personally, one of the missions that I set out in my own life was to try and make as many people aware of the Declaration as I could, because I thought it was such an important document. So we're gathered here this evening, December 10th, 2018, on what is the 70th anniversary of the adoption of the Declaration, December 10th, 1948. But what is the Declaration? Well, in short, the Universal Declaration is a primary international statement of the fundamental and inalienable rights of all members of the human family. And as such, it represents one of humanity's greatest achievements, I would argue. In 30 very crisply articulated articles, the Declaration sets forth the basic civil, political, social, economic, and cultural rights of all people. I mentioned this idea of your brother punching you in the head and you having a sense that that's wrong, but when the drafters of the Declaration sat down to work on this document, things turned out to be a little bit more complicated than that. In fact, they discovered that there was wide disagreement on a whole range of issues. First of all, from where did human rights come? Did they come from God or from the state or from the fact that humans had evolved to some sort of higher form of intelligence? The drafters couldn't agree. So just imagine that. They couldn't agree whether there was a God, whether rights belonged to individuals or to groups, whether people could own property, whether men and women were equal before the law, whether individuals could choose their own career path or had to work their entire lives in a job chosen for them by the state, whether people should have the right to govern themselves. Very basic, fundamental questions about the human paradigm and how we survive as a species on Earth. Eleanor Roosevelt played an important role, as you probably know, in adopting the Declaration. She chaired the the Committee on Human Rights that oversaw the drafting. And I'm sure that Judge Meron, our guest speaker this evening, will tell us a little bit more about the adoption of the Universal Declaration, so I don't want to steal his thunder. What I'd like to do now is just take a moment to introduce our speaker. So on the 70th anniversary of the Universal Declaration, of its adoption, on this occasion, it was adopted by unanimously. Honorable Theodor Meron will reflect on the continued importance of the UDHR and human rights on the international stage and their impact on international criminal courts in particular. You may know that Judge Meron is a leading scholar of international humanitarian law, human rights, and international criminal law. He is a scholar and an author. He has written at least a dozen books. I don't know, perhaps more. Who's counting at this point?
Not more.
Yeah. Judge Meron is also the former president of the International Criminal Tribunal for the former Yugoslavia. And he's also served as the presiding judge on the appeals chamber of the International Criminal Tribunal for Rwanda, the ICTR and the ICTY. Currently, he serves as the president of the International Residual Mechanism for Criminal Tribunals, which is sort of a merger of those two tribunals, Rwanda and Yugoslavia. And that institution carries forward the work of those two very important tribunals. So without further delay, I would like to ask Judge Meron to come to the podium. Afterwards, we'll have a few questions. Thanks very much.
It was above my station. Mr. Cooper, ladies and gentlemen, it is truly a great pleasure for me to be with you this evening. I would like to thank you, Mr. Cooper, other organizers at the City Bar, and of course my friend and former colleague Larry Johnson for helping to make this event possible. Today, of course, we mark the 70th anniversary of the adoption of the Universal Declaration of Human Rights, a document that was promulgated by the United Nations General Assembly shortly before midnight on December 10, 1948, as a common standard of achievement for all peoples and all nations. In my remarks tonight, I would like to begin by reflecting on the significance of the Universal Declaration before moving on to discuss the impact of the Universal Declaration and the human rights revolution which it has ignited on the work of international criminal courts. I will close with offering some reflections on the impact of these courts on human rights law and on the development of international law more generally. The concept of individual rights is hardly a new idea. From the Magna Carta and the English Bill of Rights of 1689 to the 1789 French Declaration of the Rights of Man and the Citizen, and the US Constitution and the Bill of Rights, there are a variety of centuries-old examples in this regard. Perhaps this fact helps to explain, at least in part, why, when the Charter of the United Nations was adopted in 1945, its cursory reference to human rights and fundamental freedoms was accepted in the absence of definitions of what those rights and freedoms might be. Yet, even if the notion of individual rights was not altogether new in 1945, the adoption of the Universal Declaration some 3 years later was a transformative event. Drafted and debated within various United Nations committees over the span of more than a year and a half, during which everything, from Confucianism to the philosophy of Thomas Aquinas, was discussed, the Universal Declaration reflects an effort to embody what itself referred to as common understanding of the rights and freedoms referenced to in the United Nations Charter, beginning at Article 1 with the proclamation that all human beings are born free and equal in dignity and rights. The Universal Declaration proceeds to set forth rights ranging from the right to life, liberty, and the security of person to fair trial rights, and from the right to seek and enjoy asylum to the right to marry and found a family. The Declaration articulates both a range of civil and political rights, such as the right to freedom of religion and speech, and the right not to be subjected to torture or to cruel, inhuman, or degrading treatment, and a variety of economic, social, and cultural rights, such as the right to education, the right to social security, the right freely to participate in the cultural life of the community. While some commentators have observed, no doubt rightly, that the final text was the result of a series of political compromises designed to ensure the Universal Declaration's ultimate widespread approval, this fact does not detract from the extraordinary power of the final product. Indeed, Hernan Santa Cruz of Chile, a member of the drafting subcommittee, described the adoption of the declaration in Paris, where only 8 states abstained and none voted against, as follows: I perceived clearly that I was participating in a truly significant historic event in which a consensus had been reached as to the supreme value of the human person, a value that did not originate in the decision of a worldly power, but rather in the fact of existing, which gave rise to the inalienable right to live free from want and oppression, and to fully develop one's personality. In the Great Hall, there was an atmosphere of genuine solidarity and brotherhood among men and women from all latitudes, the like of which I have not seen again in any international setting. Of course, much of the exceptional nature of the moment can be attributed to the circumstances of the Universal Declaration's adoption, just a few short years following the end of the cataclysmic Second World. Indeed, the Declaration itself refers to the fact that disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind. But the Universal Declaration itself was also groundbreaking in and of itself. First and most simply is the universality of the Declaration's application. From the opening paragraph of its preamble, it makes plain that the recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. We cannot underestimate today the significance of these words for those who were, in 1948 or thereafter, seeking self-determination and independence from colonial rule. Second, and relatedly, the Universal Declaration was revolutionary in its insistence on equality, in the enjoyment of human rights, and in its adherence to the principle of non-discrimination. The terms equal or equality appear some 13 times in the Declaration's short text, and the language of Article 2 leaves no room for doubt when it states, everyone is entitled to all the rights and freedoms set forth in this declaration without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Notably, this open-ended list of prohibited distinctions goes well beyond the more limited list set forth in the United Nations Charter, which refers only to respect for human rights and fundamental freedoms without distinction as to race, sex, language, or religion. Third, we would be hard-pressed today to find another legal instrument as prolific in its influence and impact on the development of international, regional, and national human rights law as the Universal Declaration. We see this confirmed at the international level in the number of specialized international human rights conventions to which the Declaration gave rise, and in the fact that the more than 170 countries that participated in the United Nations World Conference on Human Rights in 1993 explicitly renewed their commitment to the purposes and principles contained in the Universal Declaration nearly a half-century after the Declaration's adoption. We see this at the regional plane, where states in Africa, the Americas, and Europe have joined together in the regional human rights pacts. And we see this in the scores of national jurisdictions whose constitutions, laws, and the regulations either refer explicitly to the Universal Declaration or reflect its provisions and principles in whole or in part. Indeed, although it was adopted as a non-binding General Assembly resolution and something that, according to Eleanor Roosevelt, who served as chair of the drafting committee, is not and does not purport to be a statement of law or of legal obligation, the Universal Declaration has, over time, come to be broadly accepted as an authoritative interpretation of the rights and freedoms that the United Nations, as well as its member states, are bound to promote in accordance with Articles 55 and 56 of the United Nations Charter. I should pause in this context for a moment and note the not insubstantial academic literature concerning whether the Universal Declaration has also acquired the status of customary international law. I will not seek to wade into this debate now, though I would observe that there is a more robust consensus that at least some of the specific rights included in the Declaration have attained a customary status, such as the right to be free from slavery, from torture, from prolonged arbitrary detention, and from other gross violations of human rights. Whatever the answer may be on the customary status of the Universal Declaration itself, given that the various specialized international human rights conventions have not all obtained universal acceptance, the Universal Declaration remains the primary source of global human rights standards and exerts a moral, political, and legal influence far beyond the hopes of many of its drafters. I have referred just now to the other international human rights conventions that have been promulgated since 1948. These, of course, include the International Covenants on Civil and Political Rights, on Economic, Social, and Cultural Rights, which, together with two optional protocols to the Political Covenant and the Universal Declaration itself, are commonly known as the International Bill of Rights. And I'm so happy that we have here this evening Mrs. Henke, whose husband was instrumental in coining the term International Bill of Human Rights. And I salute her and I salute him. There are also, and importantly, conventions on the women's and children's rights, on the rights of migrant workers, refugees, displaced persons, racial discrimination, enforced disappearance, and the prevention of torture. That the Universal Declaration opens the way for this proliferation of human rights-focused treaties that deepened and strengthened our understanding of human rights, and the legal framework supporting those rights is undeniable. But the Universal Declaration did not simply give rise to a new body of international law. Together with the United Nations Charter, it also heralded a seismic shift in international law and the relations more generally. What do I mean by this? Underlying the post-war generation of legal instruments was a set of new ideas. The belief that certain rights vest not in the state, but in individuals. The recognition that states must not simply refrain from taking certain actions against individuals, but also have affirmative duties to provide for individuals' basic needs, and a conviction that what the state does to its own citizens and to those within its jurisdiction is not just the concern of that state, but the legitimate concern of the whole world. These ideas were revolutionary because they put individuals and individual rights at the center of international law. The changes wrought by this revolution are evident in more than just the human rights instruments to which I have referred. The impact can also be found in other bodies of law, such as notably the law of war, where the adoption of the Geneva Conventions of 1949 marked a movement away from a system based on state-to-state reciprocity and towards a framework of individual rights. Common Article 1 of the Geneva Conventions epitomizes this denial of reciprocity with its analog to the prerogative of all states to invoke obligations erga omnes against states that violate fundamental human rights. And Common Article 3 of the Geneva Conventions, by means of which the Geneva Conventions address internal rather than international armed conflicts, represents the first time in an international treaty that humanitarian law has been called upon to address internal armed conflicts and impose provision that, by many accounts, constitute pure human rights principles. Of course, alongside the rise of human rights and the rights-based discourse, there has also been an ever-increasing focus on the need for respect for and enforcement of the rights concerned and the basic principles of humanity underlying them. This sustained focus on accountability, driven in great part by the unflagging advocacy of human rights groups that helped to bring about the establishment in the early 1990s of the first International Criminal Court since the Second World War. And it is to these courts and the impact of these courts on the impact on these courts of the human rights revolution to which the Universal Declaration gave rise that I shall now turn. It was in May 1993, faced with reports of terrible atrocities being committed in conflicts raging across the former Yugoslavia, that the UN Security Council, under Chapter 7 powers, established the International Criminal Tribunal for the former Yugoslavia, or ICTY. And if I may digress, my friend Larry Johnson led the group in the United Nations Secretariat that drafted the statute. A job well done. Thank you, Larry. A year later, in the wake of the horrific events of the Rwandan genocide, the Council would establish a second court, the International Criminal Tribunal for Rwanda, or ICTR. These steps opened the way for the creation of other courts in the years that would follow, both international, such as the International Criminal Court, the ICC, and hybrid, involving an amalgam of international and national attributes. As I, as a judge since 2001, am most familiar with the work of the ICTY and the ICTR, they shall be the focus of my remarks this evening. I should underscore that neither of these two pioneering tribunals was established as a human rights court. Rather, they were both mandated to try individuals accused of serious violations of IHL, International Humanitarian Law, as the law of war is now commonly called. Nor were these two first international courts to have sought to try individuals accused of war crimes, crimes against humanity, and other such egregious acts. Famously, the International Military Tribunals in Nuremberg and Tokyo, established after the Second World War, were mandated to do exactly that, though these courts were also, in many respects, not truly international, as they were founded by the victors in the war. By comparison, the ICTY and the ICTR, often referred to as the ad hoc tribunals, were created by the UN Security Council on behalf of the United Nations as a whole. Though they may not have been the first courts to try individuals for violations of international law at the international level, the ICTY and the ICTR did mark the first concerted effort in this regard since the aftermath of the Second World War. Indeed, in the nearly 50 years that lapsed between the trials in Nuremberg and Tokyo and the creation of the ICTY, efforts to ensure accountability for mass atrocities in any courts, whether national or international, were all but non-existent. The ad hoc tribunals were also, and importantly, the first international criminal courts to be established at the international level since, and in many ways, arguably because of the human rights revolution to which I have referred earlier. Indeed, although the only explicit reference to human rights in their statutes concerned the need to give due account in the composition of chambers to the judges' qualifications, that is, their knowledge of various bodies of law, I would argue that human rights law, the body of law to which the Universal Declaration gave rise, was central to their work and to the achievement of their mandate. What do I mean by that? First, and most simply, strict adherence to human rights standards was vital to the ad hoc tribunal's legitimacy and authority. Justice, in the truest sense of the word, is not possible without fundamental fairness. While the Nuremberg Tribunal may have been able to operate with relatively minimalist procedural guarantees, it would have been unthinkable for a court established by the United Nations some 50 years after the Universal Declaration to operate without respecting the full panoply of fair trial and due process guarantees referenced in the Universal Declaration and further articulated in the political covenant. Perceptions of the legitimacy and authority of the tribunals were fragile enough during the early stages of their work for other reasons. Had they not rigorously applied and scrupulously adhered to the highest human rights principles, I have no doubt that their work would not have gained the respect that it has. Given this, it is not surprising that the influence of human rights law is palpable in both the statute of the ICTY and the statute of the ICTR, even if not referenced explicitly therein as a source of law. Notably, in the lead up to the establishment of the ICTY, the UN Secretary General explicitly indicated that the new tribunal should take into account international human rights when it came to fair trial guarantees, stating that it is axiomatic that the International Tribunal must fully respect internationally recognized standards regarding the rights of the accused at all stages of the proceedings, as contained in Article 14 of the Political Covenant. The language of Article 21 of the ICTY statute and Article 20 of the ICTR statute both track the language of Article 14 of the Political Covenant in many respects. The influence of international human rights law is evident in other provisions of these statutes as well, from the acknowledgement of the availability of appeal and review, provisions not present in Nuremberg notably, to the express provision of avenues for pardon and commutation of sentences. But that is not all. Importantly, in extensive rules of procedure and evidence elaborated by the judges in the early days of each tribunal and frequently amended thereafter, the core guarantees in the statutes of the ICTY and the ICTR were elaborated upon and transformed into specific procedures. This was no easy process and involved synthesizing practices drawn from different legal traditions of the judges and their interpretations of the fair trial standards at issue. The judges had to devise procedures that would be viable without any police force to enforce rulings, and had to develop rules for the admission and treatment of evidence more generally. They had to develop mechanisms to protect victims and witnesses, while balancing such protections with the desirability of having public court proceedings. They had to devise rules governing defense counsel, who, unlike prosecution counsel, were not staff of the tribunals themselves, and to provide for a legal aid system. And the judges had to address issues as basic and administrative as official languages and translation, and as fundamental as judicial impartiality and disqualification of judges. As I hope this list suggests, there are a great many components of the tribunal's rules that turn on or implicate international human rights considerations and go well beyond the guidance given by the Universal Declaration or even Article 14 of the Political Covenant. Not surprisingly, the statutory provisions to which I have referred and the dozens of rules of procedure and evidence developed to guide the proceedings and uphold fair trial guarantees gave rise to hundreds, if not thousands, of rulings, demonstrating yet again the centrality of human rights to the tribunal's functioning. At the same time, myriad procedural questions were raised over the years to which the statutes and the rules of the two tribunals did not offer explicit answers. Time and again, judges looked to human rights principles and precedents to answer these questions. Thus, for instance, in a 2001 appeal in the Celebici case, the ICTY was called on to consider what inferences could be drawn from the decision of an accused person not to testify. While the ICTY statute made plain, in line with the political covenant, that an accused may not be compelled to testify against himself, Neither the statute nor the rules explicitly identified the consequences of a failure to testify, unlike the corresponding provision in the Rome Statute of the International Criminal Court. As appeals chamber in that case drew upon the reasoning of the European Court of Human Rights and other sources to conclude that in the absence of express such statutory safeguards and warnings, an accused's silence could not be considered in the determination of guilt, which is, I note, the same approach which was followed by the ICC. Other examples abound. In the Furunzia appeal judgment, the ICTY was guided by the European Court's jurisprudence concerning the right to a reasoned opinion. And in a 2007 decision, in the Perlic et alia case, the ICTY turned to the European Court's precedents in relation to questions of admissibility and evaluation of evidence. The ICTR similarly had occasion to refer to the jurisprudence of the European Court as well as that of the Human Rights Committee. Your husband was a member of it, Mrs. Hankin, which monitors implementation of the political covenant, including in construing the right of an accused to be informed promptly of the reason for his arrest and the nature of the charges brought against him, and this came up in the Barayaguiza and Kajaleli cases. In the same Barayaguiza case, the ICTR appeals chamber was also called upon to address questions regarding the circumstances in which a court may insist that a defendant is represented by counsel. Questions that, when raised in the ICTY in the case of Slobodan Milosevic, President Milosevic, led to lengthy considerations of the jurisprudence of the Human Rights Committee and of whether the right of an accused to self-representation may have to yield to the overarching right to a fair trial in certain circumstances. In ruling on that question, the ICTY appeals chamber adopted the basic proportionality principle employed in human rights jurisprudence in holding that the restrictions on Milosevic's right to self-representation should be limited to the minimum extent necessary to protect the tribunal's interest in assuring a reasonably expeditious trial. It bears noting that the tribunals did not always take a consistent line as to whether they were bound to abide by international human rights law wholesale. Indeed, in dealing with certain issues, they engage in something of a balancing exercise, interpreting provisions of instruments such as the political covenant in the context of the respective tribunal's object, purpose, and unique characteristics when weighing questions such as witness protection versus a defendant's right to face his or her accuser, or the right to provisional release pending or during trials. Not surprisingly, there has been some criticism of this balancing approach and of the manner in which the tribunals were set to look to human rights law and jurisprudence in a piecemeal or selective fashions. Criticism of the tribunal's approach notwithstanding, it is undeniable that human rights principles were central to the development of the tribunal's extraordinary corpus of procedural jurisprudence. Human rights law also played a vital role in the context of the tribunal's substantive jurisprudence. That is to say, the tribunal's rulings addressing the crimes under their jurisdiction. Time and again, the tribunals looked to human rights law and legal precedents for evidence of customary law, so as to ensure that the principle of legality was fully respected, and for guidance in interpreting the somewhat skeletal substantive provisions of their statutes. For instance, in the ICTY's Knożela case, the trial chamber considered the requirement of the crime of arbitrary imprisonment as a crime against humanity and expressly relied on human rights law as set forth in the Universal Declaration, the Political Covenant, the Inter-American Convention, and other sources in addressing this question. In the Salibici case, the ICTY trial chamber once again relied on human rights law to reach a definition of inhuman treatment as a grave breach of the Geneva Conventions. Notably, the definition eventually distilled tracked the approach of human rights jurisprudence by defining inhuman treatment in the relative terms, that is, as an act or omission that deliberately causes mental or physical suffering, but fall short of the severe mental and physical suffering required for the offense of torture. In a number of other cases, the tribunal chambers were called upon to address what acts constitute the crime of persecutions on political, racial, or religious grounds as a crime against humanity. In the Kupreshik et alia case, for instance, the ICTY trial chamber looked to the Universal Declaration and the two covenants and concluded that it was possible to identify a set of fundamental rights, the gross infringement of which may amount to a crime against humanity. In other cases, chambers likewise concluded that the discriminatory denial of classic political, social, or economic rights, such as the right to employment, to freedom of movement, to proper judicial process, and to proper medical care, as discussed in the Berdanin appeal case, can, in certain circumstances, rise to the level of the crime of persecutions. The treatment by the tribunal of the crime of rape offers another important example. The ICTR's very first case, the Akayesu case, was groundbreaking in many ways, not least because it was the first case at the international level to rule that rape and crimes of sexual violence could, in certain circumstances, constitute the crime of genocide. The Akayesu chamber, as well as a number of trial chambers at the ICTY in the years that followed, would draw upon human rights precedents and norms, such as those concerning human dignity and physical and moral integrity, to construe and clarify the elements of the crime of rape in the context of several different international crimes. In doing so, these chambers, as had so many other chambers at both tribunals, were relying in part on human rights norms to interpret and lend greater specificity to the prohibitions contained in international humanitarian law. Without such specificity, when it comes to the elements of crimes, and without the ability to root their work in core principles of international law in this manner, the work of the pioneering International Criminal Tribunals would not have been possible. I have been speaking thus far about the impact of human rights in international criminal tribunals. Before concluding, I would like to touch briefly upon the impact of these tribunals on human rights and the development of international law more generally. As the examples I have given just now suggest, over the more than 2 decades of their existence, the ad hoc tribunals, while not human rights courts themselves, produced an extraordinary body of jurisprudence interpreting and applying a wide array of human rights norms. In doing so, the tribunals not only made it possible to carry out their own mandates in a principled manner and demonstrated in no uncertain terms the continued significance of many of the rights articulated in the Universal Declaration, they also made remarkable contributions to the development and broader understanding of human rights, providing courts in other jurisdictions with valuable precedents demonstrating how human rights principles may be applied in practice. The tribunal's contributions in this regard are particularly notable given that existing human rights courts and bodies have exclusively civil jurisdiction and may not be called upon to directly resolve the full panoply of matters that the criminal court typically adjudicates. Indeed, through the application of provisions such as Common Article 3 of the Geneva Conventions and the exercise of jurisdiction over crimes against humanity, the ICTY and the ICTR, while not human rights courts themselves, have in many ways enforced quintessential human rights. In doing so, they have addressed, if only to a small extent, a hole in the competence and enforcement capabilities of regional human rights courts, and made all the more evident the extraordinary synergy between human rights and international criminal justice. In addition, through their nuanced jurisprudential discussion of substantive issues involving both human rights and international humanitarian law, the ICTY and the ICTR also contributed to a growing convergence in the applicability of these two fields, with the principle of humanity serving as the common denominator. Through this convergence, many of the gaps in application once thought to exist between these two bodies of law have been reduced or eliminated, broadening the scope of humanitarian protections and the rights-based legal framework, and thus advancing key aims underlying the Universal Declaration. Let me offer one final example in this regard, this time concerning the crime of torture as a crime against humanity. While torture is universally condemned and prohibited, international humanitarian law does not provide a definition of torture. Accordingly, the trial chamber in the ICTY's Kunarak et alia case turned to human rights instruments and jurisprudence to determine when an act constitutes torture in the context of international humanitarian law. By the way, Kunarak was my very first appeal case in the ICTY. Notably, while the trial chamber began by considering the definition of torture provided in the UN Convention Against Torture, it went on to hold that this definition was not reflective of customary international humanitarian law because it required, as one of its elements, that the act in issue be committed by or at the instigation of a public official. The trial chamber reasoned that this element was a result of the context in which the UN Convention Against Torture operates, with states as respondents, and is therefore directed only to obligations of states. However, the trial chamber concluded that for the purposes of the ICTY, the involvement of the state does not modify or limit the guilt or responsibility of the individual who carried out the crimes in question. On that basis, the trial chamber held that the involvement of a state official or other authority is not necessary for an act to be regarded as torture under international humanitarian law. In affirming this ruling, the appeals chamber took pains to make clear that while the definition of the crime of torture in the Torture Convention may be considered to reflect customary international law As far as the obligations of states are concerned, this does not mean that the definition of the crime of torture set forth in the Torture Convention wholly reflects customary international law regarding the meaning of the crime of torture generally. This is yet another example of the impact of the tribunals on the development of human rights and of how, through their work, the ICTY and the ICTR enhance the protective character of bodies of law that, though they remain distinct with different scopes of application, are reflective of common principles rooted in the Universal Declaration that we celebrate today. 10 years after the Universal Declaration was adopted, Eleanor Roosevelt gave a speech at the United Nations to mark the occasion. I hope you will forgive me if I end by quoting from her speech on this occasion as we mark the Declaration's 70th anniversary, where she asked, after all, do universal human rights begin? In small places, close to home, so close and so small that they cannot be seen on any maps of the world. Yet they are the world of the individual person, the neighborhood he lives in, the school or college he attends, the factory, farm, or office where he works. Such are the places where every man, woman, and child seeks equal justice, equal opportunity, equal dignity, without discrimination. Unless these rights have meaning there, they have little meaning anywhere. Without concerted action, citizen action, to uphold them close to home, we shall look in vain for progress in the larger world. Her words ring true today, as sadly the struggle continues here in the United States and in communities and countries the world over to ensure that human rights are respected as we go about our daily lives. Yet, as I hope my remarks have illustrated, we should not ignore the extraordinary impact and significance of broader efforts to uphold human rights at the international level, including the impact and significance of the work of international criminal tribunals. These tribunals, while established outside of the field of human rights, have nonetheless made unparalleled contributions to the understanding of human rights, to the promotion of these same rights, and the norms underlying them, and crucially, to our ability to enforce these rights when they are abrogated, whether in our own communities or on the other side of the world. Indeed, we cannot and must not ignore the contributions of these courts. Rather, they are something to be celebrated, just as we celebrate today the extraordinary Universal Declaration itself. And I thank you.
Thank you, Judge Meron. That was incredibly moving. As you were speaking, it reminded us of Eleanor Roosevelt's great question that she asked, where after all do human rights begin? In small places close to home. It dawns on me that if we ask the question, where after all do human rights end, it would be in your courts, at the ICTY and ICTR and at the International Criminal Court, where the most egregious crimes against humanity, war crimes, genocide, the highest level, are brought before the court, and those accountable are held to account. If I could, we'd like to open up the floor for a few questions, but I'm going to take the chair's prerogative, if I may, to start with one question that was on my mind. I mentioned earlier that Judge Meron has written a number of books, and there are a couple of his books that I have found very fascinating over the years. He's done some incredible work on looking at the work of Shakespeare and its relationship to international humanitarian law. And I was going back through one of the 2 or 3 books, I think, that Judge Meron had written some time ago called Bloody Constraint, War and Chivalry in Shakespeare. And I'd like to ask you a question along those lines. First, if I may, from the book, I have a short quote that sort of describes, I think in the most succinct way that I found in the book anyway, your feeling about what is chivalry. And I'll just read that quote for you, if you don't mind. The humane and noble ideas of chivalry included justice and loyalty, courage, honor, and mercy. The obligations not to kill or otherwise take advantage of the vanquished enemy, and to keep one's word, Sanctity of the chivalric oath was particularly important, and the duties to protect the weak, women, widows, and orphans, to help people in distress, to be gentle, to act nobly and generously, to redress wrongs, to avenge injustice, and to renounce the pursuit of material gain, but not the spoils of war or ransom. That's your definition of chivalry, at least the most succinct one that I found in the book. At another point in the book, you mentioned that for Shakespeare, honor and shame are the central forces that motivate and shape our behavior, chivalric behavior. And my question for you, judges, in this day and age, when we find that among our political leaders, and this is a political question, if I may, but it's a legal question as well, that there is no honor or shame, where does that leave us when we think about international law? In the books that you've written, you made this direct connection between this sense of chivalry and the emergence of international humanitarian law. So if we lose those values that underpin chivalry, have we lost the power of international humanitarian law? What's the connection between our values and the law?
Thank you for first reading my book. And second, I presume you even bought it. And for asking this question, we are assuming that many of the norms that govern or should govern our universe have been created today or yesterday. What attracted me to the work of Shakespeare on war, which focused on the wars primarily between England and France in the 15th century, among others, was Shakespeare's deep understanding, which I think we will be hard-pressed to find parallel today by anyone. Imagine a person before the invention of electricity, before the laptops, computers, electric lamps, even flashlights, sitting at night with a candle and reading chroniclers such as Holinshed and Hall and others, to learn, and Plutarch, and try to learn about how in history norms were, people tried to enforce norms. I say tried because it was not necessarily more successful than that it is today. But like then, we are moved by ideals, by principles, by objects, even if we fail to enforce them, or the life would not be worthwhile living. We would just give up. And the technique that was used by chivalry was the idea of honor and shame. And perhaps the gravest punishment was imposed on knights who violated those rules of chivalry. It was called, in the language of Shakespeare and of the Middle Ages before that, to commit treason to chivalry. And the typical sanction to be imposed would be, for instance, to deny a knight spoils of war that he captured in a foreign country. The sanction or the deterrence would be strong enough to deter knights or other knights or mercenaries from serving for that particular night. But the gravest, the more severe sanction at the time would be to send soldiers to an estate of a knight and to reverse his coat of arms. And they had even a Latin term for it, which was reversio armorum. I probably making a mistake or two in repeating that. But knights were taught to, there were stories, documented stories of knights who have committed suicide because they could not bear the shame which was inflicted on them. But at that time you also had something about which we hardly hear nowadays. You had courts of chivalry in England and in France with international jurisdiction. And if they could get hold, for instance, a chivalry court in France of an English knight, they would not hesitate to apply to him the entire set of chivalric law, force him, for example, to go back to his country, bring back ransom which he failed to pay, although he promised to pay. So there were ways of enforcing this law. Now we are facing a period which is very, very difficult, with some very senior people not being very impressed by international law, by human rights law, by international humanitarian law. But the alternative is not despair. The alternative is to continue supporting those principles and trying to make them survive when the going is rough. And eventually, the principles will win. Just as the Universal Declaration has survived all these years as a winning document.
Thank you. Have we found the offending device that's beeping? Okay, we're working on that. That's Lauren. So, while Lauren's taking that, I'm wondering if someone could person the microphones for us on the floor. Ken, would you do us the honor? Or a young lady here, just over here. Lauren was going to do the microphones for us, but since we're having Oh, good job. Sound is gone. The microphone's headed your way. Why don't we start with this gentleman here in the second to the last. Sorry. Actually, if I could, our colleague from the Jacob Blaustein Institute for the Advancement of Human Rights, just in the back row here. And then we'll go to you, sir.
Thank you so much. Kristen Broker with the Jacob Blaustein Institute. Judge Meron,
is the microphone on? Can we just double check that? Good. Okay.
Great. I'll speak up. Judge Meron, I appreciated your remarks, and I was struck particularly by your comments about how the fair trial and due process guarantees that are embedded in the statutes and the procedures of the ICTY and ICTR, and which were derived in part from the Universal Declaration, were fundamental to the perception of their legitimacy. And in light of that, I'm just wondering, what's your perspective on the more recent developments we've seen in UN efforts to respond to mass atrocities that seem to be encouraging UN-facilitated investigation, but not the judicial component to go along with it? I'm speaking of the mechanism created by the Security Council to look into crimes in Iraq, the mechanism for Syria created by the General Assembly, and the most recently created mechanism by the Human Rights Council to look into Myanmar. It seems to divorce the investigation from the prosecution and defense components, and I wonder if you find that to be encouraging in that it's an innovative response to a difficult political moment, or troubling in that it seems to reduce the likelihood of scrupulous adherence to fair
Thank
trial.
you for your questions. The mechanisms which have been established for Syria and are being established for other situations, I would view them positively in the sense that they are better than not doing anything. The problem with prosecutions and courts is that you have to preserve evidence in a very professional and careful way. And even in our court, we find it so difficult to find evidence that is credible, that would be persuasive before a court of law. And not doing anything, investigating, trying to collect carefully and professionally evidence in, say, with regard to atrocities committed in Syria or in Burma or anywhere, would be bad. I wish the mechanisms which are being now established by the United Nations would contain one more stage, namely the possibility to present that evidence to a court of law which would be given a competence, especially by the United Nations Security Council, acting under the binding Chapter 7. I will not reveal any secrets to anybody by mentioning that there is no way to do that, because there are some countries in the Security Council which will not wait more than 2 minutes, if at all, to veto such proposals. Then the question is, do you do anything or don't you do anything? Now, I think that we should have an incremental approach. And if we have those bodies on investigation which have collected evidence, let's hope that one day the mood in the Security Council will change, that the relations between the major powers will improve, and there will be consensus on establishing on creating appropriate criminal jurisdiction. You know that we were very lucky in the ICTY and the ICTR. They were established during a period of a relative gap in the Cold War. Imagine that somebody would have proposed the establishment of the ICTY today. I don't think that proposal would go very far. We have to act whenever opportunity arises, and hope that those opportunities will come sooner rather than later. So is it an ideal answer? It is not. Is it better than doing nothing? Yes, it is.
Great. We have the microphone. Okay, there we go. Perfect.
Hello, Jan Hesburger from the Office of the High Commissioner for Human Rights. Coincidentally, my question is about the very same mechanisms for independent investigation. I mean, looking back at the experience of the ICTY and ICTR investigations, is there any advice you could provide on pitfalls to avoid, lessons learned for the type of work this independent investigative mechanisms will undertake?
Just stay away from politics. Adhere as much as you can, totally, I hope, to principles of due process and fairness. And be careful not to contaminate by mistake evidence that could be vital for future establishment of individual criminal responsibility.
Great, Lauren. Maybe we could go. There's a gentleman here with a yellow shirt, and then we'll go to Jim and then Larry, if that's okay. Anybody else?
Sir, you made comments regarding the Nuremberg war crimes trial to the effect that the due process rights afforded the accused were insufficient or inadequate. Are you accordingly criticizing the verdicts meted out or sentences imposed upon any of the defendants? As you know, the Soviet Union favored summary execution for the accused. Furthermore, are you, by extension, also critical of the Eichmann trial in Jerusalem?
Thank you.
Well, the Eichmann trial, first of all, to start from the end, presented problems in terms of establishing Israel's jurisdiction. I don't think that I can say anything new about it. As regards Nuremberg, I'm glad that you asked this question. Let me remind all of you that if you count the rules of procedure which were adopted by the Nuremberg Tribunal, could I have a guess from someone? Could you tell me, do you think how many rules of procedure there were? Can you guess or remember how many rules of procedure the did Nuremberg operate under? Well, to the best of my recollection, there were 11 rules of procedure. 11, can you imagine? Conducting an major international criminal trial with 11 rules. To give you just a comparative statement, we have more than 100 rules, and many of them actually contain B's and several rules under the same 97A, 97B's, 97.3, and so on. For us, just in the ICTY, the rules of procedure encompass something like 140, 150 pages. Nuremberg started from a very minimalist approach. You remember that both Churchill and Stalin had somewhat different views from having courts of law adjudicate cases of Nazi war criminals. Eventually, better sense prevailed. Churchill did not insist and simply tried to turn some of his suggestions, describe it as a joke. Stalin could not prevail. And Nuremberg Tribunal started from minimalistic due process. There was no provision, for example, regarding who bears the burden of proof. And the Soviets, in the beginning of the trial, argued that the burden of proof should be carried by the accused. There was no provision regarding appeal, which we regard as a fundamental right of due process. There was a right to ask for the Supreme Military Council for clemency. But this would be given, if at all, as a matter of grace, and it was not an effective appeal procedure. Now, what was interesting that while the court started, Nuremberg started its work as a military tribunal, very harsh, very severe, very few due process norms, trials in absentia, or convictions in absentia allowed, the right of the accused to be present in a court meeting in which he was discussed, not necessarily confirmed, and so on. No appeal. While the start was very disappointing, over time, actually Anglo-Saxon concepts of due process penetrated the court more and more. And eventually, the trials that came out were reasonably fair. Nobody in the beginning of the Nuremberg trials expected that there will be any acquittals. 3 people were acquitted in Nuremberg, and these were the major war criminals who were charged with committing most terrible atrocities against humanity. There was a provision first saying that regarding criminality of organizations, if you could prove that if you could establish the criminality of SS, for example, or Gestapo, which was not very difficult, and then you would have only to prove that X or Y belonged to Gestapo or the SS as a basis of his conviction. You would not be expected to prove anything about what he actually did. Did he believe in it? Did he not believe in it? Did he do anything? Was he a commander? Was he a follower? All those questions were expected not to be dealt with because of the notion of criminality of organization. But then the Nuremberg judgment revised this approach and said that you need to commit those crimes knowingly, that it's not enough to be just a member of an organization. You have to prove that he himself committed certain crimes. So the judgment itself may not be perfect in some of its statements. For example, it regarded crimes against peace as crimes which were already established prior to the Nuremberg Charter and were completely in compliance with the principle of legality. Nevertheless, it was a reasonable judgment dealing with reasonable points, and the fact that it was reasonable was that it was followed and given, it was subsequently approved. The Nuremberg principles, as you know, were subsequently approved by the General Assembly of the United Nations. The trial, the occupation courts established under Control Council Law number 10 followed these principles, and over time, the judgments of Nuremberg, I think, won general recognition. In giving them general recognition, I think that we do not do our job in also criticizing aspects, criticizing the fact that more norms of due process were not articulated and applied. It could have been better, but it was, for example, much better and more adherent to due process than, for example, the Tokyo Tribunal. So, would I give A to the judgment? I don't know, but certainly I would not fail it.
May I just add in passing that sentences imposed upon Schacht and Speer were commuted to serve their full sentences. In lieu of an appeal, that you referred to.
Not right away.
If we could Jim Silkenet up in the corner here, our former president of the American Bar Association, and then we'll go to you, Larry.
We now have 70 years of experience with the Declaration and have seen the important ways it has shaped international conduct. Assuming you could get immediate acceptance from member states, what changes, if any, would you make in the Declaration to make it stronger, more effective?
I think that usually by trying to amend a document which has proved its effectiveness, its moral force, its legal impact, we usually, by trying to improve, we usually spoil. And moreover, I think in the present international climate, if you would take any generally accepted instrument which we regard largely as customary law, for example, the Geneva Conventions. Imagine you ask the General Assembly or the International Committee of the Red Cross to convene a conference to quote-unquote improve or tinker with the Universal Declaration, with the Geneva Convention in this case. I think what would come up would be a document which would be extremely disappointing, and probably with regard to most of the norms contained in the Geneva Conventions, you would not have consensus now. Think about any of the important documents or international treaties in the area we are discussing in human rights or humanitarian law. Imagine that you would present the Security Council tomorrow with the statute of the ICTY, which does not exist any longer, but the statute of the mechanism, and you would ask them to revise it. The statute of the mechanism is now based almost verbatim on the predecessor institutions, ICTY, ICTR. I think we would get an extremely disappointing instruments. From time to time, we see proposals in the international community, for example, to the International Committee of the Red Cross, to revisit the Geneva Convention. I think that would be a calamity.
Larry Johnson, just here in the front row.
Thank you very much, Judge Meron, for agreeing to come and give such a fascinating and important talk, and thank you for your kind words. I wanted to follow up on what Kristen and the colleague from Human Rights Center mentioned, which is these new mechanisms for evidence collection with no particular court. The other shoe is not there. But at least in some of them, the other shoe is going to be domestic courts. And I'm thinking in particular of the difficulty of the Iraqi team, which is a Security Council blessed project, endeavor, that is to assist the Iraqi authorities to investigate and prosecute ISIS. Now, a good number of members of the council, I think last week there was the first debate on it where the Karim Khan, who is the special advisor, the head of the team, a British barrister, and also I think has appeared before ICTY and other places.
He appeared many times before.
Indeed. He made his report, and four of the members of the council specifically said, yes, you can help the Iraqis develop evidence and forensics for mass graves and help them develop their cases. But in no event will you use UN-developed evidence for the purposes of the death penalty. Now, at the end of the debate, the Iraqi spoke, and the Iraqi said, all of this is based upon Iraqi sovereignty, Iraqi jurisdiction, and Iraqi law. And so we are welcoming assistance on the part of the United Nations, but we will follow. And it comes back to, in some ways, the 48 Declaration and the Covenant. He cited particularly Article 6 of the Covenant, of the Civil and Political Rights Covenants, which allows the death penalty in certain cases. And he said, this is what they're going to apply, and it's premature to make any conditions about using evidence for purposes of the death penalty. Now, I think my question to you is in the case of IHL, where you have domestic prosecutions for war crimes under Geneva, some of those countries have death penalty, if I'm not mistaken. So this is not something for ICTY because ICTY, ICTR didn't have the death penalty. So you didn't run across that problem there. But I was just wondering, in terms of your own thinking and your own writing, have you come to any conclusion about the death penalty and how it fits into the progressive development of human rights law, or IHL?
Thank you, Larry. Well, I adhere to the policy of the United Nations, which is clearly abolitionist. I do not believe in capital punishment. I think we had problems with capital punishment that we actually overcame. You remember when the ICTR was being established, in the beginning we did not have the support of Rwanda, because Rwanda insisted on us being able to somehow be complicit with capital punishment, either by doing it ourselves or having their support with that. The United Nations took a strong, principled position that the United Nations does not support capital punishment, and eventually the the Rwandans gave in and cooperated in a way with the tribunal over the years. Perhaps we could have defined that cooperation in different ways, or come up with some suggestions as to how it could be improved. But that particular problem was overcome. So I don't think that one can make progress by capitulating on principles that it took such a tremendous effort for the international community to develop. Whatever the consequence, we cannot. However, I am in favor of helping Iraq with prosecutions which would be conducted according to due process. I think anybody who is involved in this field of criminal justice realizes that the international courts will never, ever be able to do the entire job themselves. We do not have the resources. We do not have the people We do not have the possibility, and we do not have the political mandate and the judicial mandate, except to try very few, very senior people. So the future, we can only achieve lasting results if we persuade member states to take over the burden, to take the torch from us, be guided by our example, by the precedents that we develop. For instance, our brand new principles that we have developed regarding how we define rape, which are a tremendous advance on existing national criminal law with regard to rape. For example, the notion that you do not have to, the prosecutor does not have to show that there has been continuing resistance, that you do not have to show that weapons were used or threatened, that it is enough to establish that rape occurred in a coercive environment in which consent cannot truly be given and so on. But those principles must be now followed by national jurisdictions. And I think that the future of international criminal law lies in some kind of a synergy between principles that we develop on the international plane and enforcement, which must be largely done by national state governments. We just cannot do the job alone. So we must have an incremental approach. And to the extent that we can encourage the Iraqis to have some meaningful and due process prosecutions of people from ISIS, let them do it.
Another question here. Ken, please. If there are no more questions on the floor, I think after Ken's question, I'll close us out, if that's okay.
You've indicated that the Universal Declaration is a practical, long-standing document, but may not be a perfect document. You told of abstentions during the vote, there were political compromises, there were omissions. There may not be consensus today if there were a vote. What, if anything, do these say about the concept itself of universal human rights?
Well, I have not yet seen a single document which people would agree is absolutely perfect. The fact that there were some abstentions actually reinforces the value of the declaration. There were no votes, and there were only 8 abstentions in the entire General Assembly in Paris. I think we should be very impressed by those results and not see them as something negative. Also, I have not yet seen a single treaty, a single document, or a single resolution in the United Nations of any importance, which in the process of being adopted, did not involve some political compromises. You cannot get anything through unless you compromise. The question is whether you compromise on vital principles or on things which are not of that same vital, critical importance. And I do think that one of the very impressive things about the declaration, in terms of the core of your question, namely universality, is that the Universal Declaration is cited in the constitutions and in the laws of so many countries. It will be very difficult to find a country that did not refer, at least briefly, to the Universal Declaration. Its moral impact, it's amazing. You asked about Shakespeare and medieval rules. Those chivalric rules were not statutory. They were customary, and they were moral. But if I gave you the example of a knight who committed suicide because he was found guilty of being a treason to chivalry, how many people today would commit suicide because they have committed they've committed violations of international human rights or humanitarian law. Let's try. You perhaps cannot be in my field without being somewhat of an optimist, because if you are not, then why be in it?
Thank you, Judge Meron. Before I close us out and ask you to give a final round of applause, the Honorable Judge, I'd just like to make an appeal to the crowd. I was thinking as Judge Meron was talking, I was reminded of a quote. I think it's Ambrose, a famous American poet and author, who said that war is God's way of teaching Americans geography. And I was thinking about Yugoslavia. I worked in Albania for the International Rescue Committee during the Kosovo crisis, and then in Kosovo for UNHCR. And I remember when I came back to the States, my brother and my family would, if my brother was introducing me at a bar, he would say, "Oh, you know, Michael worked in Bosnia." And I thought, I've never been to Bosnia, actually. I was in Kosovo and Albania. So I'm not so sure that that war does teach us geography. But it raised this issue of Yugoslavia. Why Yugoslavia? Why did we have to wait 50 years for this to happen? And you said that we have to seize the moment when we can to advance the law. It might not happen again for another 50 years. We don't know. So along those lines, thinking about seizing the moment, you know, today is the 70th anniversary of the adoption of the Universal Declaration of Human Rights. Some years ago, 20 years ago, in fact, I had helped to put together the U.S. campaign to mark the 50th anniversary of the Universal Declaration of Human Rights. And one of the things that we learned during that campaign was that it takes a lot of lead time. We had 2 or 3 years to sort of think about what we wanted to do and how we wanted to use that occasion to advance the cause, to advance the struggle. Because it is an ongoing struggle, and it never ends. I think we've learned that in, you know, recent political developments have shown us that there's no end game here. We have to keep fighting to the end of time. So my appeal to you is today, on the 70th anniversary of the Universal Declaration, that we as a community start to think ahead about the 75th anniversary and what our obligations are and how we can use that occasion to really move the ball forward. Today has been a special honor for me, Judge Meron, to have you here with us on this auspicious occasion. I would like to invite you all first to give a round of applause to Judge Meron and then to join us for a small reception afterwards. Judge Meron, thank you so much.
Thank you so much.